Picture this. A company sells a gadget that promises to protect you from the flu. They're so confident. They advertise a £100 reward to anyone who uses it and still gets sick. And to prove they're serious, they say they've deposited £1,000 in a bank. Now imagine you follow the instructions, still get the flu, and the company refuses to pay. That's exactly what happened in Carlill versus Carbolic Smoke Ball Co, a case that turned an ad into a binding contract. Background story: in the late 19th century, influenza outbreaks were sweeping through Britain. The Carbolic Smoke Ball Company marketed a small rubber device filled with carbolic acid powder. Users were instructed to inhale the vapors several times a day, supposedly preventing flu and other illnesses. The company ran a bold newspaper ad. £100 reward will be paid to anyone who contracts the flu after having used the smoke ball 3 times daily for 2 weeks. According to the printed directions, £1,000 is deposited with the Alliance Bank, showing our sincerity in the matter. Mrs. Louisa Elizabeth Carlill bought a smoke ball, followed the directions, and still got the flu. She claimed the £100 reward. The company refused, arguing the ad wasn't meant to be a serious contract. Issue: was the advertisement a legally binding offer, and had Mrs. Carlill accepted it by performing the specified conditions? Rule: under contract law, a valid contract requires offer, a clear promise capable of acceptance, clear agreement to the offer's terms, consideration, something of value exchanged, intention to create legal relations. The key principle here was the unilateral contract, where an offer is made to the world at large and can be accepted by anyone who performs the required act. Application: Mrs. Carlill argued the ad was a clear offer. The company even deposited £1,000 to prove seriousness. She accepted the offer by using the smoke ball as instructed. Consideration existed. She bought the product and followed the required steps. The company argued the ad was mere puff or sales talk, not intended to be legally binding. There was no notification of acceptance. The Court of Appeal sided with Mrs. Carlill. They held that the ad was a serious offer due to the deposit of £1,000. Acceptance was through performance. No need to notify in advance. The unilateral contract was complete when she fulfilled the conditions. Conclusion: Carlill versus Carbolic Smoke Ball Co. 1893 is a landmark case in contract law, clarifying that advertisements can be binding offers if worded clearly and seriously. Unilateral contracts require no advance acceptance notice. Performance is enough. From a bizarre flu cure to one of the most cited cases in contract law, this story proves that sometimes bold marketing promises can come back to bite. Legally, if you say you'll pay and someone meets your terms, you'd better be ready to open your wallet. If you're enjoying these case law breakdowns, make sure to subscribe and comment below which famous contract case you'd like us to cover next.